Hey guys, my name is Shashwat and I'm a legal intern at LEXIS and Company. In this video, I'm going to tell you about the Writ of Mandamus, which comes under the right to constitutional remedies. According to the 9th edition of Black's Law Dictionary, Writ of Mandamus is one of that issued against an inferior court, a government body or officer by a superior court to rectify an action of the past or omission to act along the lines of the responsibility that they are entitled to. Writ of Mandamus can also be issued by against public corporations and the tribunals, as it is directed to set the indolent authorities to the task. It is also described as a wakening call, dictating their activity and setting them in action in pursuance of discharging public duty. The topic arises is what are the grounds of writ mandamus, writ of mandamus. Mandamus is remedial in nature and cannot be expressed as a writ of right, as it is issued only at the discretion of the courts after the applicant of the same is able to prove to the court that some utilitarian or just question would be answered by the writ. The essential grounds are that firstly there exists a legal sanctioned right of the petitioner or the applicant of the writ, and a violent violation of compromise of this right has been committed. Then the infringement of the rights of an applicant can be done by public authority in the following manner, like crossing the limits of powers and duties vested by their office, then failure or omission of the act responsibly according to the condition laid down by the law, then also by the denial of an officer or authority to perform the statutory duties. Then there come one ground there where another ground for the legality of issuing the right of mandamus is the failure to act or perform the legal duties despite being demanded by the applicant for the same. It was upheld by Supreme Court in the case of Saraswati Industrial Syndicate versus Union of India. Also, the writ should be applied in a good faith without any ulterior motive or intent on the part of the applicant. Lastly, the writ of mandamus can only be issued when no other course, redressal mechanism or legal alternatives have been left at the disposal of the applicant. Then comes the types of mandamus. There are three types of writ of mandamus. First is certiorarified mandamus, then anticipatory mandamus, and then the third is continuous mandamus. The limitations of the writ of mandamus are that firstly the private persons, institutions and organizations, if default, cannot be held accountable for their inaction by the issuance of mandamus. Then the second limitation is that if the duty or the activity that is in the question of the public authority is not mandated by the compulsory obligation but is discretionary in nature, the writ of mandamus cannot be issued by the enforcement of such duties. Then thirdly, the writ of mandamus cannot be issued against the head of the state, and that is the president on the national level or the governor on the state level. Then there comes a limitation that the electoral matter has been kept away from the writ of mandamus, from the purview of the writ of mandamus, and those officials that are engaged in different levels of the electoral process cannot be directed by the mandamus. However, this is applicable only for the elections of the union and the state parliament. Mandamus can be issued in the matter of concern relating to the municipal level elections. So that is it from my side. In conclusion, I may say that the writ of mandamus can slightly be described as a legal instrument or ensuring general public interest, safeguarding their rights promised to them in the constitution and other laws in the land. It is also an effective mechanism for maintaining accountability of the state or public authorities, and mandamus is essentially a pro-democratic mechanism, statutory obligation. So, thank you.